Oral arguments began this morning in the lawsuit against the governor's office over tax refunds. The Democrats in the legislature are alleging the governor is using money from the Tax Refund Efficient Payment Trust Fund for operations and want the court to clarify whether money in the fund is supposed to be only used for tax refunds.
We're here today for a very basic question, and we look for it's a very basic answer as well. Is the legislature authorized to enact laws restricting the use of certain revenues strictly for tax refunds?
In his brief, the legislature's attorney John Terlahi alleges the governor has violated the law despite taking the position that he has the discretion to disregard the mandates of the law as long as he finds a way to pay tax refunds in a timely manner. Today, Terlahi says the law relative to the trust fund does not restrict the governor's collection authority or to give out refunds, but it does affect the legislature's budget process. Chief Justice Robert Torres, however, questioned the manner and urgency in which the case was brought to the court, considering that refunds are current.
But this has supposedly been going on for more than 20 years, and there hasn't been a big rush to come to the Supreme Court to get a declaratory judgment previously. So it apparently hasn't prevented the legislature from going through and budgeting, even with the alleged failures of the governor to, violations of chapters 50 and 51.
Well, the reason that the refunds are caught up today was because of the major act of the legislature approving a bonding bill to come in over $120 million to come in and pay these tax refunds. Now, this wasn't the governor picking out, well, I'm going to take it from the general fund and pay $120 million out. This was a great act on the legislature part. We're here, and again, we're here saying if we don't take out the money and we don't budget, then what are we facing at the end?
Assistant Attorney General Shannon Taitano, meanwhile, says the Income Tax Refund Efficient Payment Trust Fund is a valid act and it unambiguously restricts the use of money in it. The court, however, noted that in the AG's amicus brief, they stated the judgment may not be appropriate for review because of undue delay. However, Chief Justice Torres questioned whether the Paeste order in federal court could constitute why the case should not be delayed.
I think the court could decide to hear this case in the interest of judicial economy. Although it is our position that not all the 40104 requirements have been met, because Governor Calvo has been paying refunds in a timely manner. However, he will not be governor forever, and the government has a history of not being able to pay refunds in a timely manner.
The governor's chief policy advisor, Arthur Clark, had previously spoke with KUAM on the lawsuit, saying it was a waste of time. Today, he spoke on not only the jurisdictional requirements, but the mootness of the issues raised.
If they're not limited to just a review of their own actions or questions clarifying their authority and duties, Your Honor, then any time any law passed by the legislature is not followed, even if it's a criminal statute, Your Honor, that would open up the precedence for the legislature running into court saying we've passed a law that isn't being followed, we'd like a judicial review of it.
Justice F. Philip Carbolito, however, noted that the court is not going to determine if withdrawals were made and how it's been used, but instead, should the case proceed, determine if the legislature has the power to restrict the use of funds. Clark spoke on how the legislatures over the past decade have over-appropriated money and over-projected revenues, so when public resources are unavailable to meet 100% of needs, the governor had practiced his executive authority. He adds when the administration came in, they inherited a $400 million operational deficit, $300 million of which included tax refunds, which resulted in the governor going after a bond. As for the use of the funds in the account, Clark says it wasn't the intent of the law when it was first enacted, but agreed with the interpretation that the law has provided a form of bridge financing or a line of credit that can be drawn down when funds are not sufficient.
But if it's utilized in such a manner where if general operations, there's not sufficient cash and there's $60 million sitting in the trust fund, that so long as the governor has the intent to repay it, it can withdraw the funds and use it for other operations, because if you say it's his general responsibility in overseeing the proper function of government, and then when there's sufficient cash in the general fund that he can then go back and repay that. So that's how it can operate.
But what about, for one example, if revenues drop and the governor is unable to pay it back?
That's actually been the case, Your Honor, over the last 20 years, and that's how we accumulated this deficit.
So at that time is when the violation occurs? Because you say that so long as he has the intention of repaying it, and he repays it, then everything is okay.
What I'm saying, Your Honor, is because he's repaid it, the issue was rendered moot.
The governor's legal counsel, Sandra Miller, meanwhile, noted that it is permissible to pay tax refunds out of the general fund. She adds that if the governor has to advance money from the general fund to pay tax refunds, then he can later recover that money from the trust fund. Clark ultimately says that this lawsuit is disingenuous because the overarching requirement has been satisfied in that tax refunds are being paid and in a timely manner. The court will now take the arguments under advisement. Reporting for Guam's News Network, I'm Ken Quintanizo.